Hello and welcome to our Coffee and Consulting from this week about the topic cross-border commuter, the risk of permanent establishment. That is, at least looking at our daily business, one of the hot topics we do have. And we got some support and help from our Austrian colleagues. Michael Obernberger and Sieglinde Buttinger will hold the Coffee and Consulting event today with us together, as they are the Austrian tax experts. Before we start, two housekeeping rules. One is on the right-hand side, you will find the slides from today's presentation. So if you want to download them while the presentation is live, then please do so. Then you have them also later on. All of you are on mute basis. So if you do have any questions to any slide, to any topic or anything we raised today, please write your question down in the box with questions, which you will also find on the right-hand side. And we will try after the presentation to basically answer all the questions. If there's not enough time for it, then we will definitely get back to you afterwards. So I think we can start, and I will hand over to Michael Obernberger and Sieglinde Buttinger.
Thank you very much for this warm welcome. First of all, I would like to introduce my colleague. Next to me is Sieglinde Buttinger, who is our expert regarding international taxation based on employer and employee level here at ARTUS. My name is Michael Obernberger. I'm the partner responsible for international taxations here at ARTUS. I would like to say thank you to Friederike and the whole Convenus team for giving us the chance to having this webinar together with you, because from our perspective, it's also a hot topic we are presenting today, and it totally makes sense to have this cooperation, Switzerland and Austria, to present this topic from at least two sides. I would like to start with the permanent establishment from a national and international perspective. They are almost the same. It's all about the fixed base on a national territory. It's about exercise of a business and economic activity. One of the difference between besides the duration is that the definition of the PE from an Austrian perspective is a little bit broader. For example, we don't have this support services which can create a PE from an Austrian perspective, but from OECD, for example, these supporting services are excluded and do not trigger a PE. So this is the main difference. From a practical perspective, CEO activities, branches, etc., lead to a PE, so it's nothing special. But we do have some issues from an Austrian perspective regarding home office, because Austrian tax authorities treat home office like a PE in some cases. And we will see later on in which cases home office may trigger a PE. On the next slide, we will have the secondment and the personnel list. What is here the crucial triggers regarding the PE, and this will be presented by Sieglinde.
Yes, hello also from my side. I may say a few words to the differentiation between secondment and personnel lease. Yes, secondment, here it is a service or any other work that is owed for the fulfillment of a contract. This is under the supervision of the employer, and the customer has usually no authority to issue any instructions. The secondment has an economic value for the employer. Hence, there is the risk of creating a permanent establishment in the country of employment if the secondment takes longer than 6 months. So if the employee stays for a longer period in the other state. When we talk about secondment and assignment, it is always important to know in whose interest the employee's activity in the other state is, as there are different tax consequences between secondment and personal lease. In case of a secondment, the interest is usually at the employer's side, and in case of personal lease, the interest is usually at the hosting company. In this connection, I have an example. A marketing strategist from the parent company is seconded to the subsidiary to implement a marketing strategy at the subsidiary. If this is in the interest of the parent company, then the parent company remains the employer for treaty purposes. That means in the other state, there is the risk of establishing a permanent establishment. Yes. The personal lease is different to the secondment because the economic employer can shift to the other state. What are the differences between secondment? In case of assignment of employees, no service or work is owed, but rather the provision of employees is owed. The leased employees shall be integrated to the hosting company. Then they shall be subject to the host company's supervision and shall work with the company's equipment. And they shall not produce any work distinguishable from other products or services of the host company. The company which leases the employees is still the legal employer. However, as mentioned, the economic employer can shift to the hosting company, which could result in a tax liability for the employee from the first working day on. Furthermore, the company shall not be liable for the success of the leased employee. In principle, a PE is not established in connection with personal lease. However, the hosting company has to withhold 20% tax when they pay out the remuneration agreed between the legal employer and the host company. This tax can be refundable if the employees themselves comply with the taxation in the hosting country and if no PE is created. This is usually the case. Another option would be to apply for a relief at source. This, however, is only applicable in case of intra-group transfers of employees or if the Austrian tax authority has issued an exemption notice to the employer. In both cases, there is the condition to withhold wage tax for the employees in the relevant countries. Now I have two examples. I read it. A consulting company based in Italy offers its services also in Austria. Always the same office is rented in 14-day intervals. In between, there is no disposal over the office in Austria. So we have in this case a fixed establishment that is used over a long period of time. So also recurring activities with interruptions can create a PE in Austria, even if the 6 months are not reached within a 12-month period. In this case, the period under consideration is several years. We have a business activity in Austria, and the Italian company has the power of disposal over the premises in Austria. So yes, the PE creation is realistic in this case. Another example, an Austrian company seconds an employee for the duration of 12 months to the Chinese group company so that he or she can train employees in the operation of a machine. The costs for the training are charged based on the personnel costs plus 10% markup. Yes, there we have to check in whose interest the activity of the employee is. If it is the interest of the parent for control and coordination, then we have a PE risk. If it is just a personal lease because the other company has a lack of employees, then we have basically no PE risk. Then also it has to be checked if it is a service PE. A service PE can be created if the consulting activities are carried out within a period of 12 months for a duration of at least 6 months. For one and the same project or a related project, Austria has service PEs in some double tax treaties, for example, the double tax treaty with Czech Republic or China. Yes. Next page, please.
Thank you. Yeah, like mentioned before, home office is a very specific and hot topic from an Austrian perspective right at the moment, because Austrian tax authorities treat home office to be at the power of disposal of the employer, even if it's the private apartment of the employee. Of course, there need to be met to meet some conditions, like it's not only temporary, so the threshold is 25% of total activity is performed in the home office, and of course you need this business activity link. So in the home office, business needs to be performed. But from our perspective, this is a little bit weird, because at least we are used to this power of disposal, and my private apartment cannot be at the disposal of my employer. So that's a bit strange for us, but that's the opinion of the Austrian tax authorities right at the moment. And from our experience, we are facing, especially with Germany, some issues, because Germany is neglecting this home office to be a PE, and this can result, like mentioned on this slide, or can end in the risk of double taxation, because Austria is taxing the PE due to the home office, and Germany is neglecting the home office and taxes the whole thing 100% as well. So we have double taxation. And on the other hand, there also might be some cases we have double non-taxation. When I was preparing for this webinar, just a few days ago, a Supreme Court decision came up, and now it seems like it's the first Supreme Court decision regarding this home office stuff, triggering PE, yes or no, and now it seems like it's going a little bit backwards, and home office is not triggering a PE at any circumstances. Yeah, so we will see how this will proceed, but it's not as risky or dangerous like it was, I would say, some weeks before. But home office still is a hot topic, especially with the double taxation, because other countries, especially Germany, has a completely different approach on this home office issue. We also mentioned Switzerland on this slide, but we have the expert Friederike on the webinar, so maybe you would like to jump in at this stage to give us an input regarding home office from a Swiss perspective.
Sure, I do. Yeah, the home office, in Switzerland, I would say we are, compared to Austria and Germany, still a bit more relaxed on that topic. We only would really look at, or the tax authorities would only really look at it at anything which is for a longer term, so not really temporary, but more permanent. And from a Swiss perspective at the moment, they still are reluctant to say that the home office from an employee can really be viewed as a permanent establishment, because of what Michael just said as well about the disposal of the apartment from the employer. But up to now, there's no court decision. There's nothing from the tax authorities which is kind of binding, or where we can see that is where everything will go. We will just have to see in the next few weeks, months, maybe years, what the tax authorities will come up.
Okay, thank you. Just another input from my side. We have some binding information from the tax authorities saying if you're spending more than 25% in the home office, you don't have another office offered to you by employee, then you're pretty close to the employee. And now this Supreme Court decision I mentioned is not 100% to the home office. It's about desk sharing in a shared space office. So it's pretty close. It's all about this power of disposal, but it's again not 100% with this home office stuff. But at least we got some more arguments to get out of this home office PE. I would like to mention as well that it's also important how the labor contract is concluded. Because, for example, if it's from the beginning clear that there is no office space the employee can use, he has to, it's mandatory for him to work from his or her home office, then we are still pretty close in this PE issue. Yes, this is from home office perspective. On the next slide, I have some pretty simple examples just to give somehow wrap up. It's all three different examples. They have together, it's an IT employee. The first example, this IT employee is working for a group company from his Austrian home office. In this case, this IT employee is providing auxiliary activities, support services, but this activities is rendered not only for his employer, but for the whole group. And then this creates a permanent establishment in Austria due to the fact that it is some kind of support services, but it's rendered to at least more than one company, or different from his employing company. And the second example, it's still IT employee working, but this time for his German employer company. He's still working from his Austrian home office. We still have, again, auxiliary activities, but in this case, no PE is triggered in Austria because it's just auxiliary activities for his employer company. So small differences with big impact. The last one, it's an IT manager working from his Austrian home office. And linked to this word manager, we come up to the conclusion it's not an auxiliary activity anymore because it's another level of seniority. And therefore, our conclusion is that we do have a permanent establishment in Austria, although he's working again still from his home office. Due to the fact that we have a PE, then of course we have some declaration and tax obligations in Austria for the employer company. Thank you. Please go ahead to the next slide. Yeah, this is somehow a summary upfront conclusion, let's say it like this. It's about how can a PE be avoided from an Austrian perspective. First of all, if we have to check if there are auxiliary or supporting services, then they do not trigger a PE. Besides, we provide this to more than one company. And yeah, listed on this slide are these typical auxiliary activities like storage, stocks of goods, purchasing and information procurement, and so on. But from my perspective, these are general auxiliary activities which should be familiar to most of you, I would assume. Yeah, big highlight again on this slide, if this auxiliary, if we check if there are auxiliary services, we cannot stop by saying, okay, these are supporting services, no PE, check. We have to go one step further and say, okay, to whom we are providing this type of services? To more than one company? If yes, then again, we end up with the PE. If it's just one, then it's not a PE. So please keep this in mind as well. On the next slide, before we come to some examples from our experiences, I would like to end up with some short conclusion. Yeah. First of all, caution with cross-border activities of employees. Always keep in mind that the PE risk or PE topic we need to check, or you need to check on a regular basis, because sometimes you check it when you start. For example, in Austria doing business, you came up with a conclusion, okay, this is not a PE, but from time to time, maybe the employee or the services the employee is providing are changing. Maybe it's becoming more than supporting services. He's supporting more than one company. So please always check on a regular basis the PE. Of course, then we have this profit deferral issue. If we end up in the PE, then we have to think about the transfer pricing. We have to think about the correct transfer pricing method and so on. But this is a topic on its own, to be honest with you. Of course, if you have a PE, it's mostly linked with additional compliance costs, because you have this compliance costs in your home country and in the country of the PE. But maybe an advantage is, besides that, the risk you can manage, because if you know you have a PE, then you can manage the risk. So that's one advantage. And another maybe the tax burden is lower in the country of the PE. It depends, of course, case by case. That's the conclusion from my side, and the next slides are more practical, I would say, because we have some samples now compared with Switzerland and Austria.
Thank you so far. So to check now, or to see on two samples, we prepared two samples where you can see now the Swiss side as well as the Austrian side to the sample, which might help for your daily business as well. We kept it quite simple because it's still quite complex, the whole thing, and you need to, in the end, really look at and consider lots of different aspects. So we have Anton, Austria. He's an Austrian national, lives in Austria, is employed at Trinks AG in St. Gallen in Switzerland, and he has the position of the CFO. He would like now to continue to work 3 days in the office and 2 days from home. So for any cross-border employee, not just now that one, you always have to look first in regard to labor law, which are the relevant provisions you need to consider. And in that regard, because he's working in Switzerland as well as in Austria, in the end, you will have to look at both. You have to consider from both the mandatory requirements and to make sure that you are complying with that. From an immigration perspective in Switzerland, we would request a cross-border permit for him, and basically it also doesn't matter whether he will commute on a daily basis or stay the 2 days in one turn. For the cross-border permit, that is not relevant. Social Security, he will spend or work 3 days in Austria, so he will be subject to Austrian Social Security, and we from the Swiss side, we just would need a copy of the A1, so that in case there is any kind of checkups from the Social Security Authority in Switzerland, that we can present that document as proof that no Social Security has to be deducted in Switzerland. From a tax perspective, he is only working 2 days in Switzerland, even if the payroll will be made in Switzerland and Anton will get the salary paid out in Switzerland. Switzerland has only the right to tax the effective physical days he is performing work in Switzerland, and therefore on those 2 days he is working, we would have to in the end deduct the withholding tax, and we would use the normal tax tariff depending on the marital status as well as the dependent children. What would be required, or what is quite helpful, or you need to have in the end, as a calendar filled out by the employee in order to make sure that you really have taxed the effective days he is spending in Switzerland. So make sure that you always look at the right days and the effective days the person has spent in the calendar. Payroll side, I already said we do need to have one in Switzerland, because there will be also the payout from the Swiss company, and we need the payroll as well for deducting or calculating in the end the tax at source, or the withholding tax. However, we also would need one in Austria, which would be then the shadow payroll, for also making sure that the Austrian Social Security has been calculated correctly and can be deducted. So I hand over now to you, Tu, for the Austrian side.
Yes, I will present the Austrian perspective. From a labor law perspective, it is the same as it is in Switzerland. Basically, we have free choice of labor law. Only mandatory. There are only mandatory provisions in both states that are to be applied. For example, continued payment of wages in case of illness, working hours and work rest regulations, vacation law, and or various protection regulations. From a social security perspective, Austria would be the responsible state for social security. A1 form has to be applied at the Austrian Health Insurance Fund. Yes, it always has to be carried with in case the employee is in the other state, in this case in Switzerland. For a tax perspective, Austria has the right to tax 100% of the Swiss income, and the taxes that are withheld in Switzerland are to be credited in Austria, because the credit method is applicable in Austria for tax residents in Austria. From a payroll perspective, it depends on the fact if a PE is created or not. If there is a PE, then we have the obligation in Austria to withhold wage tax. So a payroll has to be conducted in Austria. If there is no PE, a shadow payroll would be recommendable in order to calculate the Austrian social security contributions that are to be paid to the Austrian insurance fund. Yes.
Perfect. Can I just ask one additional question, just out of curiosity? Is there is because he is the CFO of the Swiss company, do you see then from an Austrian point of view a higher risk of the creation of a PE, or does Austria not really look at that?
From my perspective, we had examples before with the home office of on senior level. There is, of course, a higher risk than only for auxiliary activities. Yes. But as mentioned, there is the new decision from the highest court. Maybe it now will not be classified as a PE anymore.
Yeah, at least the risk is a little bit reduced.
Yeah.
But yeah, we have here is the top management level is the CFO. Yeah, spending 2 of 5 days from home. So we still have risk here to create a PE. Yeah.
Okay.
Especially if it comes up with some strategic decisions, he may be. If he's doing this from his home office in Austria, then we can also discuss about switching the seat of the company to Austria, but this is a low risk, but we can think about this because, yeah, it's always so the strategic decisions are made, then there's the seat of the company from a tax perspective. So just to mention this as well.
Okay, super, thank you. So we look at the next sample, which is basically just we changed it to Reto Swiss, who is a Swiss national. He lives in Switzerland and is employed at the Trinks AG in Vienna in Austria. He's also has the position of the CFO, but for now for the Austrian company. He would like also still to continue to work 3 days in the office and 2 days from home. So 3 days he will work in Austria and 2 days he will work in Switzerland. From a labor law point of view, it's actually the same thing. When you issue the contract, you will have to consider the Swiss mandatory provisions. Because he's working 2 days in Switzerland, and that on a kind of regular permanent basis. Social Security, because he's working for 2 days in Switzerland, he will be subject to Swiss Social Security. Now here, because if he is working for a foreign company, then we will have to kind of enroll him as an employee without a registered employer in Switzerland, which is not an issue. He will be basically also subject to all the social security departments as anybody else. The only thing is that it might be a bit tricky from time to time to get really the necessary pension funds, at least the one you really want to have, or with the conditions you really want to have, because there we will be a bit limited in the availability. From a tax point of view, because he is Swiss national, therefore he just has to file his tax return. Basically the 2 days he's working in Switzerland, that is what Switzerland can tax here. And the income the income which have been taxed in Austria already for basically for the other 3 days, we will have to declare in the tax return as well, but we only consider that for determining in the end the tax rate. In Switzerland, we would usually run a shadow payroll just for calculating the Swiss Social Security, and that's it. Maybe one more thing to it, because of that special way he will be treated in regard to Social Security. all the insurances like pension fund, accident insurance, and the daily sickness insurance will be usually then in the name of the employee as well. So that is a bit different to others. So what will happen on the Austrian side? I will hand over to you now.
Yes, from a labor law perspective, it is the same as before. Immigration, there has to be applied for a registration certificate within 4 months of the entry in case of a domicile in Austria. If the stay is longer than for 3 months, and basically there is free access to work in Austria. From a social security perspective, Switzerland is the responsible state in this case, and the employee has to have the A1 form with him whenever he is in Austria. From a tax perspective, or the income that is attributable to working days in Austria is taxable in Austria because of the employer in Austria, and the income attributable to working days in Switzerland is tax exempt in Austria. Payroll in Austria, there we have the employer, hence there is yes, the obligation to withhold wage tax, and the income attributable to Switzerland can be considered tax exempt. Yes, based on the working days calendar in Austria, those days can be tax exempt. Yeah.
One question maybe from my side. If we somehow amend this example and Retro Swiss is working 1 day in Italy, for example, as well, how does this change from maybe Swiss perspective?
If he's working for 1 day anywhere else, you mean?
Yeah, correct. Yeah.
I mean, from a Swiss perspective, we would tax that one. No, yeah, we would be the one who will be taxing that 1 day spending abroad, because he will have residence in Switzerland, and therefore Switzerland will say we have the right to tax that day. And from a social security point of view, as long as he's over those 25% working in Switzerland, we would also have social security in Switzerland.
So it's the same from Austrian perspective.
Yes, in Austria, only working days spent in Austria are taxable in Austria.
Yes. Yeah.
Do you look at the effective days in every month, or you can, I mean, because in Switzerland, we really have to look every month exactly on the effective days somebody has spent or has worked in Switzerland, and then need to run the calculation on that effective basis. So usually we are not able to have the right number of days already by the end of the month or before we have the payroll run. So we always have then to go do an additional payroll run for the previous month to make a correction in case the whatever assumption we have made is not correct.
Yes, according to my experience, I think it is possible to do this on an estimate, 20% Switzerland, 80% Austria, for example, and then correct to the correct days in line with the tax return.
Okay,
So
but can you do that on
Yeah. Sorry?
Do you need to make the correction then on a monthly basis, or you can do that on an annual basis?
So it is possible to do this then at the end of the year with the annual tax return. Yeah.
Okay, perfect. Thank you. So now basically we would have now time for any kind of further questions in this regard. And I already have the first question. So if anybody of you would like to take the opportunity and the chance to get now the insight and information from the two experts, Michael and Sieglinde from Austria, you have now the opportunity to do that. And I will try to get the Swiss part as well. So use the time now. While I already read the first question, which is, what if we are not talking about 3 days, 2 days per week, but maybe 3 to 5 days per month? So not every week. So maybe we just go back on the sample. If we use now the sample for Reto Swiss, who is employed in Austria, and he's now working 3 to 5 days per month in Switzerland, and the rest he is working in Austria. So from a Swiss perspective, the change will be that basically there will be no social security liability in Switzerland any longer. And from a tax point of view, it will be the same, because we just will, whatever days the individual is spending outside of Austria, we will tax in Switzerland. What would you do from an Austrian point of view, Michael or Sieglinde?
Yes, social security would shift to Austria then, and from the tax perspective, it's the same on all days that are spent in all working days that are spent in Austria are taxable in Austria.
Yeah, and of course the home office PE would be, the risk would be reduced because it's only a few days per month.
Yeah. Okay. I hope that was answering the question. So the next one is, what is the situation with companies that have headquarters in both Switzerland and Austria, and therefore have employees who sometimes attend meetings in both countries for individual days? Would you like to answer first, or shall maybe I answer? If Austrian employees coming to Switzerland, I mean, we would call them, or put them under the category business travelers. So basically the main part will be about immigration and getting the days notified here in Switzerland, or get a proper 120 days permit, so they are able to work in Switzerland. We usually have then the issue that the Austrian salary level is not in the same range as what the immigration authority in Switzerland will request. So there needs to be a top up to be paid. And from a tax point of view, usually the income or the salary or compensation will be not charged to the Swiss headquarters or to the Swiss company, and therefore we usually exempt them or from Swiss income tax. So there will be no income taxation in Switzerland, and they would remain in Austria in the Austrian social security, and therefore there's also no problem with that. We also in Switzerland only rarely really have check-ups on the A1s. However, what we've seen and realized, there are increasing number of check-ups at the companies, and therefore we definitely recommend to make sure you get the A1 in time for the business travel, as well as you do have the right proper work permit in place. So what would you do in Austria?
Yeah, if it is no personal lease, then it would be basically the same as only the other way around. Yes, the employee would need an A1 form for the other state. Yes, you would be taxable in no, it doesn't would not be taxable in the other state because it does not reach the 83 days. And what else? We considered.
No, it's just a business trip.
Yeah. And the minimum wage, there is also a notification to be made if employees are seconded to Austria, then ZKO3 notification has to be made. This is for guaranteeing the guarantee that the minimum wages are paid, which is usually paid in Switzerland.
Okay, perfect. So the next question would be, is there any guidance from Switzerland and Austria on dependent agent PEs and what sales employees would be permitted to do from a home office that is used irregularly, say 2 to 5 days per month? I can say from a Swiss point of view, I mean, if there is a salesperson here in Switzerland who is employed outside of Switzerland, so the employer is not in Switzerland situated, in principle, we work still on that kind of general rule that the salesperson should not sign any contract. So that for the last part of the sale, that will all go back basically to the employer or to the headquarter, to the company, and they only sign contracts. And then mostly in Switzerland, you won't have an issue. However, in Switzerland as well, there was a kind of or the tax authorities recently thought that they see that people are doing exactly that. They are, the salespeople will negotiate everything with the client, and it's almost at the point where all the conditions will be negotiated, and then it's just a matter of formality that the contract will be sent back to the company for the signature. And they are now trying to find a way how to best approach that and to make basically the salesperson based on that being or creating with that the permanent establishment. So that's from a Swiss point of view. Is there from an Austrian point of view?
Thank you. From an Austrian perspective, it was like this until some years ago. It was just like you mentioned, they negotiated everything, I would say 99%, and then sent the contract for just formal approval to the headquarters, and then there was no PE in Austria. But there was a shift in mindsetting and some new regulations in Austria, and now they say if you're de facto negotiation almost everything, and this is just the final formal approval, and in almost every case this approval is done by the headquarter, then it's still a PE. So it's not anymore the case that you can say I'm just not signing. I'm doing everything final. I'm giving discounts. I have this. Yeah, I'm completely done this negotiation. Yeah, just to source out the signing process to headquarter is not working anymore to avoid the PE. Yeah, that's the conclusion. So it's getting stricter, or it is already stricter.
I just have sometimes the feeling that Switzerland just looks what is Austria doing and what is Germany doing, usually give both of the countries a bit of time to see what the kind of what there will be in practice and happening based on that, and then Switzerland comes with something like this as well. I mean, it was the same thing with that economic employer principle, where we learned from Germany and you, and now we do have also something like that.
Yeah, we had the same approach, like looking what Germany is doing, but like mentioned with this home office issue, we just did something more stricter. It did not be in line with Germany at all, and now we have this double taxation issues, or at least the risk of. So sometimes it's better to wait and then come up with similar regulations. Yeah.
Okay, so then we have another question, which is, if a company has headquarters in Switzerland and Austria, the Swiss employee has a Swiss contract but works 3 days in Austria and 2 days in Switzerland, would the personal lease agreement be recommended? That is now a question for you.
Yes, personal lease is, however, only possible if the employee is then integrated in the Austrian company.
Yeah, maybe I start interrupting, but it's important not what's saying on the contract, personal lease or not, depending on what is the case at hand from an economic perspective. What is the employee doing? What is the goal? What are the both parties want to achieve? And then we can classify this as personal lease or not, with the consequences from tax and social security system.
If the employee is only in Austria to train other employees, then it maybe will be a secondment, and a personal lease would then be the wrong approach.
Yeah, so it's not a question of choice. It's more what is the case at hand, and then it's the one or the other.
But would there also be the possibility to have kind of dual contracts, like the employee is getting a contract for the 3 days in Switzerland, and he will get a direct contract with the Austrian company for the 2 days?
Split contract would be an option, of course, yeah. It would then be easier to handle, maybe, because then we would have already the payroll in Austria and we would have the payroll in Switzerland, and the employee then has no tax obligations at the end of the year. Yeah.
I know that from an administrative point of view, I mean, as an employer, you usually don't want that, because then you have all these discussions about taking holidays at what, and work hours, expenses, and whatever. But sometimes I think in such situations, it might be the easier, in order not to get into discussions with the tax authorities from both countries, and it's a bit of more straightforward process.
Yeah, you have some kind of, let's say, more documentation. You have more clarification, maybe, because you have this conflict.
Yeah, and one employer has to register for social security in the other state. Yeah.
Okay, and then there is one last question. What would you advise a Swiss employer if they send employees to Austria? Where should they be the most careful with?
So, sorry, can you repeat what the risk is, or what's the?
What would you advise a Swiss employer if they send employees to Austria? Would you recommend that the Swiss employer is doing to avoid any risk, or lower the risk as best as possible? I think in regard to taxes, social security.
Yeah, in general approach, it's important to think about the situation before you put it into practice, to check what can be the risks, and then at least you know it. Because what we want to avoid for our clients, that they come here and then they say, oh my God, this risk and these obligations and these compliance costs, I didn't know. If I didn't know them, I would never come to Austria, for example. So it's important to have this before you start doing business in Austria, to have all these matters like taxation, PE, branch, etc. in mind, and to decide what is the best way to come to Austria. Maybe to already do business by setting up a limited or a branch or whatever. It's not always only about taxation, social security costs. It's also about market entrance and so on. So there are some different questions to be answered before entering Austrian market.
Definitely. So thank you very, very much for the insight from Austria. Thank you at the participants for all the questions. Still, in case you have now after the coffee and consulting event, maybe after lunch, you may think about what we just discussed, and you have still the one or the other questions, then just drop us an email and we are happy then to answer it and forward it to Michael and Sieglinde for their answer as well. I hope you enjoyed it. I hope you had got a bit more insight to that hot topic, which I'm sure will be one of the hot topics still in a couple of months and maybe even years. Before I close, I just want to point out two more things. One is our next seminar is next week about business travelers in Switzerland. And then the next webinar we will have is also in September, is about cross-border and all the challenges about. And then in towards now the end of the year, our newsletter will be sent out, and then there will be also an article from Michael and Sieglinde in it about Austria. So watch out for it, and I hope you all have a great week, still a good day, and not too stressful. Thank you.
Thank you from our side as well. Thank you. It was a pleasure to be part of the webinar. And again, in case of questions, please feel free to reach out to me, to Sieglinde, to Friederike. Yeah, we are more than happy to assist.
Thank you all, and have a great day.
Bye-bye.
Bye, everybody.